the point why there is such a cost incurred onto the migrant is that there are international broker fee. That's one. International broker fee is the kind of overseas broker to connect between Japanese employer and agencies. That's one. The second one is the entertainment fee, entertaining the potential employers, and also the domestic broker as well. So these kind of perhaps reducible, maybe be able to reduce the broker fee and entertainment cost should be considered in the future. And then interesting thing is that he mentioned that perhaps if these costs are reduced, perhaps the recruitment level might go down to the level of the Philippines. Regarding the from the CSO, the Sokja mentioned the kind of a community approach to empowering the community people regarding the information dissemination and the including the rights issues, the working conditions. One of the problem is that the information is not transparent regarding the work conditions and social protections, rights issues, and cost issues. So therefore, the spreading the right information, transparent information to the community would be very important. And particularly the migrants, 42% are female from Cambodia to Japan. Perhaps the reproductive rights issues and this issue is very, very important issues to be disseminated. According to the MAC, because the employer pay about, if employer shoulder the cost of $3,000 and management fee at $50 to $150 per month, like in TITP, that's common in TITP, then they don't have to, I mean, the agencies do not have to receive the money, I mean, the recruitment fee from the potential workers. Civil sector also emphasized on the spreading information should also involve the community to make the information transparent and to make the information direct information should also be needed in the community level. I think I mentioned a little bit only in my presentation that the all additional cost because of the quarantine should be borne by employer. That's what is written in the TATP program. So that's one. But of course, how it is implemented is another issue. So we have to be careful about, I mean, we have to monitor this issue. And also the vaccination is the same. All migrants, regardless of nationality or the status, are eligible of the vaccination. But of course, in the practical level, maybe migrants are afraid of the get vaccinated, even if he wants to do so. So the accessibility is different issue. But the legally, I mean, from the regulation perspective, all are actually all can get vaccinated. I think so, and also those who once they have to take the leave because of the COVID, they are eligible of the sick pay. I mean, sick leave pay from the employer. But I don't know how many percent, I mean, how much percent of the infected people really applied for the sick leave pay.
The Vietnamese government is drafting law 69, which sorry, which will which comes into force in January 2022, that states the removal of the brokerage commission payable by workers to service enterprise. And also it has a circular and a decree, and it sets a ceiling charge to migrant workers that should not exceed US 3,600 for a 3-year contract. And also service enterprise cannot charge over $260 for the Japanese training costs course, but all the other related costs are largely unregulated or unspecified. So this leaves a gray area where the ILO studies, of course, this has taken place much before the implementation of the Law 69, but it has identified that the Vietnamese workers coming to Japan and returned has actually paid between 8,000 to 900 US dollar, and that takes them like 7, 8, some up to like 10 months to repay for the debt. So this indebted condition pushed them, especially for those in the low skilled or a woman, less educated, into a very vulnerable situation where she does not have any power to negotiate with the employer and gets stuck in a condition where the employer may be very abusive. The Japanese government had issued a notice saying that in Japan, dismissal due to pregnancy is prohibited by law. And this would be should be clearly stated in the legislation as well as put into the pre-departure orientation. Molisa is also considering the ratification of some of the ILO conventions, including 189, 77, and 143, all related to migrants and domestic workers. DOLAB has emphasized as the future plans to strengthen the inspection of those private recruitment agencies. And especially, the inspection will be done every year, but especially when they have complaints from the migrant workers, they would take an immediate action for inspection. But Jane also pointed out that there's currently like 523 private recruitment agencies in Vietnam, and I don't know to what extent Molisa and Dolab both has like a function to inspect those private recruitment agencies. The issue of the reproductive rights would be put into the circular of this the new law and into the pre-departure orientation of those agencies. For the pre-departure orientation, they would strengthen the right-based approach in not just teaching like Japanese culture, for example. They would include issues like rights and terms of employment, laws, as well as the reproductive rights.
We have both administrative and also the judicial system. Either we go through the mediation process or reconciliation process, or we go to the court system that we really need a long process to go. I think in the case of Vietnam and Cambodia, it's not really different. And for we maybe, for example, maybe we have the problem with the private recruitment agency. It's easy why the migrant did not depart to Japan yet. It's easy to show through the Ministry of Labor system, right? The complaint system. However, the thing is, when the migrant worker work in Japan, and then first they were forced to return back, their employment was terminated due to any condition, but they cannot access the system in Japan. Maybe they return back to the country of origin, and the country of origin need to have a system with the Japan government that they complain even the migrant return back to the country of origin, but they still have the right to pursue their case to the justice and administrative system in Japan. I think this is something that we really need to discuss. And based on the MOC, I think a lot of focus on the recruitment process everywhere about the requirement, but about the complaint mechanism is still there. So MOC most on the exchange of human rights, but not more on the protection. Right? But if I am not wrong, when talk about the memorandum of cooperation, it also focus on the cooperation of exchange human beings rather than to discuss more about the protection, about the justice, about the right protection. So this is something from the point of view we should look at to review back on the MOC and to make sure that the protection standard is there. The justice system can be mobility between the country origin and the destination.
I just wanted to quickly add just a little bit. Cambodia has a very strong administrative complaints process, which is like an informal reconciliation process that does not have to be performed through the legal system, which has proven to be quite effective, particularly over the last 5 to 10 years. Vietnam doesn't have an administrative complaints process. It has a legal complaints process. However, there are challenges for migrant workers to access this process, such as the complaint has to come from the recruitment agency. So that is a first hurdle, obviously, for migrant workers. If their complaint is about the recruitment agency that is sending them, that recruitment agency is not going to submit that complaint for migrant workers. So in Vietnam, there is a legal complaints process for migrant workers that exists. However, we did a mapping of this process. ILO did a mapping of this process a couple of years ago, and it was not widely known by migrant workers, by employment service centres, or by migrant worker resource centres.
Tôi nghĩ một trong những cái vấn đề mấu chốt là luật pháp thì cũng đã quy định cái mức chi phí hợp lý, cái mức trần theo quy định của pháp luật rồi. Và vấn đề ở đây là cái cơ chế thị trường, làm sao mà để cho doanh nghiệp phái cử có thể tiếp cận được với người lao động mà giảm tối đa những cái chi phí không cần thiết trung gian. Làm sao để người lao động có thể biết được thông tin chính thức, biết được cái nơi tuyển dụng chính thức mà không cần phải qua những cái trung gian. Thì theo tôi, cái chi phí mà người lao động phải trả nhiều hơn cái mức quy định của pháp luật. Đó là những cái chi phí ở bên ngoài mà người lao động phải trả cho những cái tổ chức trung gian đó mà không được kiểm soát. Và một cái chi phí thứ hai, đó là một cái chi phí từ phía nhà tuyển dụng, cái phía đối tác tuyển dụng ở nước ngoài. Là khi họ có nhu cầu tuyển dụng thì họ lại thông qua một cái tổ chức trung gian mà không chính thức, và các cái tổ chức này họ lại có những cái chi phí mà yêu cầu phía cơ quan phái cử phải trả lại, phải có huê hồng, mà cái này là về luật pháp thì không cho phép. Luật pháp Nhật Bản hay là các quốc gia khác cũng không cho phép, mà luật pháp Việt Nam cũng không cho phép. Về cái phương pháp tổng thể thì tôi nghĩ rằng cơ quan phái cử cũng rất là muốn làm tốt, nhưng làm sao để có thể đến trực tiếp với người lao động và làm sao có thể đến trực tiếp với nhà tuyển dụng, thì về mặt chính sách nhà nước cũng giống như là về luật pháp cũng như là các cái cơ quan làm sao để có thể cùng đồng bộ, đồng hành để bảo vệ người lao động, thì chỉ có một cách duy nhất là làm sao để giảm bớt những cái chi phí trung gian mà luật pháp hiện tại là cũng đã nghiêm cấm nhưng vẫn chưa kiểm soát tốt được cái việc này.
Currently, no itemized list of recruitment fees and related costs exists in legislation. So, as mentioned, there are some ceiling normative documents, for example, in Vietnam that say 3,600 as a service fee should not be exceeded per 3 years and $260 per training course. However, there is no limit on other related costs like travel, accommodation, document processing, visa. It's, you know, the multitudinous other related costs. So when we see the data from the study, for example, where we have migrant workers paying $9,500 US to go to work in Japan, in theory, those could all be legal costs, right? Because there aren't ceilings. So if we look at every cost category, they could all be legal costs. So I think obviously there is a lot of work to do throughout the supply chain to ensure that migrant workers aren't exploited.
I just wanted to reiterate that in the VAMAS's Code of Conduct 4.6, it says recruitment agencies must provide fully and clearly disclose to workers all information on such fees and ensure that receipts are provided to workers. Actually, in Japan, we are creating like a checklist of the supervising organizations because a lot of companies do not know how to choose a good supervising organization, and they also face the risk that the migrants may disappear one day. So it's in one of the items of this checklist that when the employer employ a migrant worker, they have to check how much he or she has paid in the sending country. But we haven't implemented it yet. But I think this is one way to ensure the transparency.
Trong thời gian qua thì VAMAS cũng có nhận được cái thông tin là phía Đại sứ quán của Việt Nam tại Nhật Bản cũng đã có những cái thông tin trên cái trang web của Đại sứ quán và cũng có gửi những cái văn bản đến cho phía chính phủ Nhật Bản là chuyển đến các công ty tiếp nhận. Làm sao khi tiếp nhận lao động từ Việt Nam thì các công ty cố gắng thu thập tất cả những cái thông tin mà chi phí người lao động đã phải trả trước khi đi tại Việt Nam, và từ đó những chi phí nào hợp lý, những chi phí nào không hợp lý thì luật pháp đã quy định, và các công ty tiếp nhận sẽ là một cái tác nhân một cách trực tiếp để xác nhận xem cái cơ quan phái cử mà tiếp nhận từ đấy có thu phí bất hợp pháp, có thu phí ngoài cái luật pháp quy định hay không, để mà sau này có những cái việc mà tuyển chọn cơ quan phái cử cho nó chính xác. Nếu mà cái việc này triệt để làm, phía chính phủ Nhật Bản cũng hỗ trợ cái việc này, thì có thể trong tương lai sẽ từ từ sẽ minh bạch hóa được những cái chi phí cho người lao động trước khi đi.
Well, it is easy to criticize kind of recruitment agencies and government, but at the same time, I have to point out one of the problem is that the externalized costs are significant these days. It must be pointed out that foreign and domestic brokerage costs are high, rising. In particular, I should note that the growing demand of labor in Japan is driving external costs higher because company has to find the people, workers. So that's why the brokerage fee is going up. So, well, this is economically kind of making sense, as it is not easy to keep the brokerage costs down while creating the strong demand for labor. So I think it is worthwhile to note that the Vietnam's new law seeking the internalized brokerage cost into the placement fee, if I'm not wrong, the brokerage cost is included in the $3,600, which the brokerage fee is embedded into the rules and regulation that will make, I hope it will work. And also it's interesting to note that the bilateral agreement between Vietnam and Japan has a kind of sending migrant channel of a nurse and caregivers, which has no recruitment fee. This is binding on the law.
Just wanted to clarify, with the new passage of the Law 69, the brokerage commission for migrant workers has been removed. However, the brokerage commission that recruitment agencies need to pay to supervising organizations still exists in law. So the improvement is hopefully that brokerage commission will not get passed on to migrant workers, but it still exists in legislation. So something that is new in Law 69 that will be in force as of the 1st of January 2022 is a discrimination clause which prevents in recruitment any distinction, exclusion or preference made on the basis of a number of categories, including pregnancy and maternity. So that is new in Law 69 in terms of recruitment in Vietnam.